of the European Union. And if we start at the back end, what the court decided is Article 8AB5 of Council Directive 2011-16 is invalid in the light of Article 7, not Article 47, but only in the light of Article 7, right? So privacy of home and communications and stuff like that, of the Charter of the Fundamental Rights of the European Union, insofar as the member state's application has the effect of requiring a lawyer acting as an intermediary to notify without delay any other intermediary of that intermediary's reporting obligations. So it doesn't stop the lawyer from telling the client, you need to report, but it does stop, it should not tell the lawyer that he should tell other advisors that they need to report. And then what happens with Article 47, as Advocate General observed in essence in point 41 of his opinion, at that early stage, okay, we're still in the advisory stage, where this is when you do your MDR reporting, right? At the early stage, the lawyer intermediary is not acting as a defense counsel, and the mere fact that the lawyer's advice may give rise to litigation does not mean that the lawyer acted for purposes and interests of the rights of defense of his or her client, because the lawyer is not defending the client, he's advising the client on how to avoid paying tax, right? It must therefore be held that the obligation to notify the reporting obligation, in those circumstances, it must be held that the obligation to notify replacing for the lawyer intermediary bound by legal professional privilege the reporting obligation laid down in Article 8AB1 does not entail any interference with the right to a fair trial guaranteed by Article 47 of the Charter. So therefore, the directive is not in contravention of Article 47 and the right to a fair trial, which I think makes perfect sense. Now let us look at the detail of the court decisions. Why Article 7? Why is there breach of Article 7? And the decision is quite dense, so I'll try to go through it as quickly as possible. Article 7 of the Charter, which recognizes that everyone has the right to respect for his or her private life and family life and communications, corresponds to Article 8.1 of the European Convention on the Protection of Human Rights and Fundamental Freedoms. This is important. While Article 47 guarantees the right to an effective remedy and right to a fair trial, which corresponds to Article 6 of the ECHR, right? In accordance with Article 52.3 of the Charter, the Court must take into account the corresponding rights guaranteed by Article 8.1 and 6.1 of the ECHR as interpreted by the Court of Human Rights as the minimum threshold. In other words, the Court of Justice can give more protection than the European Court of Human Rights do, but they can't give less. And as we will see in this case, they have given a lot more. So let's see what the ECJ has said. It says, it is apparent from the case law of the Court of or the EC Court of Human Rights that Article 8.1 protects the confidentiality of all correspondence between individuals and afford strengthened protection of exchanges between lawyers and their clients, like, right? And then they quote the case Michaud versus France, and we'll look at that in a moment. Like that provision, which covers not only the activity of defense but also legal advice, Article 7 guarantees the secrecy of the legal consultation, both with regard to its content and its existence. It's not only that you don't have to tell anyone that what you've told your client. You don't even have to tell them that you told your client or that he or she is your client at all, right? And there's a second reference to a case here, Alte versus Turkey. I'm not looking at Alte versus Turkey because that was basically about a prisoner and the exchange of information between the lawyer and the prisoner while the prisoner is in prison, not exactly what we're talking about here. Paragraph 33, it is necessary to examine whether those interferences may be justified, because when there is an interference with Article 7, it may still be legal if it is justified. So now the ECJ looks at whether, or CJU looks at whether this is justified. It says, the rights enshrined in Article 7 of the Charter are not absolute rights, but must be considered in relation to their function in society. Provided that, indeed, as can be seen from Article 52 of the Charter, that provision allows limitation to be placed in the exercise of those rights, provided that those limitations are provided for by law, so there's legality requirement, that they respect the essence of those rights, and that in compliance with the principle of proportionality, something big in EU law, they are necessary and genuinely meet the objectives of general interest recognized by the European Union or the need to protect the rights and freedom of others. So you can breach this right to a fair trial and the privacy of communication if there are other larger rights at stake, basically, right? And then the court says, in the first place, the requirement that any limitation on the exercise of fundamental rights must be provided for by law. The act which permits the interference with those rights must itself define the scope of the limitation. So there must be a law and it must say how far it goes. And the court concludes in paragraph 38, the principle of legality must be considered to have been fulfilled because there is a directive and it tells you exactly what you can and cannot do. And Belgium has implemented that directive, right? And then the court goes further. It says, in the second place, as regards respect for the essence of the right to respect communication between lawyers and their clients, the obligation to notify entails only to a limited extent the lifting vis-à-vis a third-party intermediary of the confidentiality of communications between the lawyer intermediary and his or her client. In particular, that provision does not provide for an obligation for the lawyer intermediary to share with his client or client without his client's consent information on the content of those communications, and those intermediaries will therefore not be in a position to file such information with tax authorities. So what it says here is all that is required is that lawyer says, I can't report because I've got attorney-client privilege, you should report. But the lawyer does not have to say to the other intermediary what the lawyer said to his client, right? In those circumstances, it cannot be held that the obligation to notify undermines the essence of the right to respect for communications between lawyers and their clients. So far we're okay. But then we come to the third place. In the third place, as regards observance of the principle of proportionality, the principle requires that the limitations do not exceed the limits of what is appropriate and necessary in order to meet the legitimate objectives pursued. Where there is a choice between several appropriate measures, recourse must be had to the least onerous. So you should do the least that is practical in order to obtain your goals, right? Therefore, it is necessary to ascertain first whether the reporting obligation meets an objective of general interest. If so, it must then be ensured first that the obligation is appropriate. Second, that the interference is limited to what is strictly necessary, and this is where it goes wrong, in the sense that the objective pursued could not reasonably have been achieved in an equally effective manner by any other means. And we'll come back to this paragraph. And thirdly, that the interference is not disproportionate to that objective, which implies a balancing of the importance of the objective and the seriousness of interference, right? And then the court says, combating aggressive tax planning and preventing the risk of tax avoidance and evasions constitute objectives of general interest recognized by the EU for the purpose of Article 52(1) of the Charter. So in other words, fighting tax avoidance and evasions is a legitimate interest. On the other hand, the reporting obligation on other intermediaries and on the relevant taxpayer ensure that the tax authorities are informed of reportable cross-border arrangements. In other words, there are already other measures in place. You don't need the attorney on top of everyone else to go and report, right? And on the other hand, the disclosure to the tax authorities of the identity of the lawyer intermediary will not enable those authorities to require the lawyer intermediary to provide information about the consent without the consent of his or her client. So even if the lawyer intermediary were to report to the tax authorities that there has been an aggressive structure because of attorney-client privilege, the government can never ask the lawyer, so what did you advise? Right? And on this basis, the CJU decided that the directive is in breach of Article 7 to the extent that it requires the lawyer to tell other intermediaries that they have to report the reportable transaction. Now there's this reference to the European Court of Human Rights and the Michaud versus France case, right? And this is important because what the EU tried to do is they tried to implement the Convention of Human Rights into EU law, and that's why they say, the Court of Justice needs to look at what the European Court of Human Rights do and follow its lead. It can go further, but it must be aware of what is going on, right? And so the case of Michaud versus France We can see here a procedure, the case originated by a French national, Mr. Patrick Michaud, the applicant, who was also a lawyer, by the way, right? And the circumstance of the case, the applicant lives in Paris, is a member of the Paris Bar. He submitted that the European Union had adopted 3 directives in succession aimed at the preventing of the use of financial system for money laundering. So basically money laundering directives. The first, 91308, targets credit and financial institutions, but it was amended by 2001-97, which among other things widened its scope to include professions outside the financial sector, including members of independent legal professions, right? And then the law transposing these directives have been incorporated in the Monetary and Financial Code, which I assume is the French law, and these texts place lawyers under an obligation to report suspicions with which the legal profession, who sees it as a threat to the professional privilege, have constantly criticized. They said you can't expect us as lawyers to report transactions which we suspect has to do with money laundering, which I think is a rather strange claim to make, but okay. However, in 12 July 2007, the National Bar Council took a decision to adopt the regulations on the internal procedures for implementing the obligation to report. So this was what Mr. Michaud was appealing against. And then let's just have a quick look at the European Convention on Human Rights, Article 8, because that's what we're talking about here. Everyone has the right to respect for his private and family life, his home and his correspondence. That looks very similar to Article 7. There shall be no interference by public authority with the exercise of this right, except such as in accordance with the law and necessary in democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the prevention of health or morals, or for the protection of the rights and freedoms of others. And those things are also underlying Article 7 of the European Charter on fundamental rights. And then if we look at what the Court of Human Rights did, they said, when we look at Article 8, we first need to see whether there was an interference with the exercise of the right protected by Article 8. And then such interference, they conclude such interference violates Article 8, unless it is in accordance with the law and is necessary in a democratic society. So now we're looking at paragraph 2, and then the court goes through this and it says, was the interference justified? Well, first of all, was it in accordance with the law? And the court concludes in paragraph 98, the interference was in accordance with the law within the meaning of Article 8, paragraph 2 of the Convention. So in so far it was okay. But did the interference have a legitimate aim? The court has no doubt that, intended as it was to combat money laundering and associated crimes, the interference pursued one of the legitimate aims. And then it goes on to say, furthermore, the court reiterates that compliance with European law is also a legitimate aim. And